I would like to introduce right now Paul Mondragon, who is the Vice Chair of the Amuh Mutsun Bangalore, who's going to do an opening blessing and welcome for us.
Good morning. Welcome. I'd just like to thank our Creator for giving us a beautiful day today and all of us having a safe travels to the university. And just ask that all the unrecognized people of the country to help us to keep our cultures alive and any way that you can. And special blessing for all the unrecognized people of the world, that they could keep themselves, their cultures and knowledge together. And just a speedy recovery for the people on the East Coast. You know, we don't go through those horrible storms like that, but we have earthquakes, and that we understand what they're going through. And just to watch over all of them and keep them healthy and safe.
So today's event is going to look a little bit different than the other events. And I just wanted to mention that we also have one of our former guest speakers here from a previous Amuh Mutsun speaker series, Colleen Sisk, who is the chair of the Wintu tribe up north. And Colleen, at the last minute, said, "I'm coming," and I said, "Yay, we'll see you," and they got here, so thank you for coming, Colleen. Again, today is going to look a little bit different because this is a precursor, and I know most likely Dr. Lonetree is going to talk about this a little bit, but this is a precursor event for a larger tribal summit that we are going to be hosting a year from now in fall of 2013 of a gathering of unrecognized tribes in California. And so we're hoping to start that planning for it at this event. So you'll notice that during the breaks we have information up on the board. If anyone is interested in volunteering and being part of that planning committee, please sign up. This is kind of old school, so please sign up. And then over the course of the day that we have together, we'll be coming up together with some goals for a tribal summit. And so we can put that on the board. I'm a visual learner, so I like to have things up where I can see them. And then we also have the goals of the tribal summit. And then over here, I'm trying to read John's writing. What are the rights and what are the issues that are extended to federally recognized tribes that non-recognized tribes do not have? Those rights that are not extended to non-recognized tribes, and I know you have a lot to say about that with what you've been dealing with in the last year. So, like 40 years, I should say. So, kind of be thinking about those things in the back of your mind. And as we take breaks and as we enter into the Q&A sessions with our speakers today, myself or the students will be writing some of these goals. And if you have any goals that come up and that you want to share later when we do our closing today, please feel free, like I said, during the breaks to come up and write down some of your thoughts on there, and we'll be recording them and keeping them as we enter into the next planning phase for the tribal summit. So what I'd like to do now is introduce two of our esteemed faculty, Dr. Amy Lonetree and Dr. John Danke. John is with the American Studies Department. Amy is with the Chair of American Studies and also with the History Department. And they're going to come up and introduce themselves and say a few words.
Thank you, Carolyn. Good morning to all of you. It is an honor and privilege to be here and asked to speak in the homelands of the Amuh Mutsun people. As Carolyn mentioned, I'm the Director of American Studies and Associate Professor of History, and a longtime member of the Amuh Mutsun Speaker Series Board. And I just want to provide a little bit more context on our group. As Carolyn mentioned, we've been meeting for several years to plan events in both the fall and the spring term, and bring in leading intellectuals and leaders throughout Indian country to talk about various issues related to indigenous health and wellness, as well as environmental issues. But what we're doing this year is slightly different. Through the leadership of Val Lopez and others on the board, and again, the board is comprised of faculty members, staff, and students from UC Santa Cruz and the Amuh Mutsun tribe. we decided to really focus on this issue of recognition. And this is going to be what we hope is an opening chapter. And we will be able to have future gatherings where we'll address this issue. So we brought in, I think, a wonderful group of speakers to share their knowledge, and we hope to continue the conversations, as you can see here, what we have on the board, just to get the conversations moving forward and really develop a working group of people who want to continue having conversations. What we don't want to see is where people come in for one event, have a wonderful day, and then we go off and never gather together again in a focused way. What we want to see is, again, a wonderful day-to-day of knowledge sharing, learning together, but only the beginning in work that we can do together. And so is there anything else?
Not really.
There's
I
on
just wanted to really welcome everybody here. It's great to see so many faces here and really nicely attended event. It's really been an honor for me to work with Val and work with the other people on the Amuh Mutsun Speaker Series board. I think we've had some really interesting events, really timely events, and really important events. And I really want to reiterate what both Carolyn and Amy have said about this being just the first step. Right? I think we have a chance here to do something that's really can be really important in this sort of multi-day workshop series that we're planning for the upcoming year. And so I just urge you to really keep in mind these sorts of questions. And if any of you are interested in working on the board for that upcoming event, please contact us afterwards. I know that Val will be talking about that a little bit more as well. So happy to see everybody here, and glad that everybody made it here. Safe travels.
So we're going to go ahead and launch right into the program. So what I'd like to do at this point in time is to introduce one of our student program coordinators and one of our student interns. And there they are. I'm looking for, I didn't see you guys. Alexis Ortega and Anthony Mota, and they are going to be introducing themselves, and they're also going to be introducing our speakers. And Steve, when you come up, we're going to put a microphone on you. Is that okay for your talk? Okay. All right. So Alexis and Anthony.
Hi everyone, my name is Alexis Ortega and I'm the Student Program Coordinator for the American Indian Resource Center. I'm Southern Paiute from the Shivers Band Paiutes, the Paiute tribe in St. George in Utah, from St. George, Utah. I was born and raised, came to school here at UC Santa Cruz. But yeah, so here's Anthony.
I'm Anthony Mota. I'm Pomo from Elam Indian Colony of Northern Lake County. I'm a freshman here at UCSC, affiliated with Brown. So, our first presenter is attorney Stephen J. Bloxham. Mr. Bloxham has extensive experience working in Indian tribes in civil litigation and business transactions involving land and natural resources, including energy resource negotiations, title and boundary limitation, and rights related and leasing negotiations. On behalf of the Navajo Nation, Mr. Bloxham has helped bring litigation against coal mining and electric utility companies alleging corruption of federal administrative proceedings concerning coal road rates. 4 years he was a member of the nation's delegation to the United Nations Human Rights Commission Working Group on a draft declaration of the rights of indigenous peoples in Geneva, Switzerland. Mr. Bloxham has served as a member of the Navajo Nation Bar Association's Admissions Committee from 1999 to 2001 and was the Northern Arizona Program Chair and member of the Executive Council of the State Bar of Arizona's Environmental and Natural Resources Law section from 1995 to 1997. And I'd like to introduce Mr. Bloxham.
Good morning, everyone. I've been introduced. Let me just tell you a few other things about me. I am an attorney. I'm with Fredericks, Peebles & Morgan, a nationwide Indian affairs law firm in Sacramento, California. I am a Northern California born and raised person and University of California educated. I graduated from law school at the University of California's Hastings College of Law in San Francisco. And before that, I graduated with a degree in Native American Studies from the University of California at Berkeley, where I found was the only place that I could study American history that actually taught American history. And I'm glad to see that American Studies and history is now unified in the coordinator for this program. My wife, Lisa, is here with me today, and she's telling me that I need to speak up. If anyone else thinks that that's the case, okay. I have a microphone on. I'm not sure how much I need to speak up, but I'll pretend I don't have a microphone. I've been asked to speak, well, let me just tell you a few other things. In addition to working for the Navajo Nation, which you've heard, and I worked in natural resources, and obviously that's a recognized tribe and the largest territorially and first or second largest in terms of population of the Indian tribes in the country. Before that, I worked for the Colorado River Indian tribes down on the Arizona-California border, and they are Mojave and Chemehuevi people with Navajos and Hopis that were relocated there at the end of World War II. And Chemehuevis are Southern Paiutes, just the Southern Paiutes. After working there, I moved back about 7 years ago to Sacramento, California, where I've lived as a child and later in my life, and began to work for a law firm. And in the process, I've come to work for several unrecognized Indian tribes, including primarily the Shinnecock Indian Nation back on Long Island, New York, which still has its power out unless things have changed last night, on Long Island, bearing part of the brunt of Hurricane Sandy. And also its neighbor, the Unkechaug Nation on the Puspatuck Reservation, also called sometimes the Puspatuck Tribe, also on Long Island. And there is a reason historically why most of the unrecognized tribes are in the eastern states, the original 13 states, and also in California. The reasons are different and also the same in some ways. When I began working for the Shinnecock Indian Nation, I brought one of the eastern land claims that you've, I'm sure, heard about over the years. A number of the tribes in the east, particularly the original 13 states, because the original 13 states didn't think that the Indian Non-Intercourse Acts applied to them, felt free to engage in treaties even, and land transactions with Indian tribes in violation of that statute. The federal government generally did nothing about it, in part because the tribes were considered to be what we would now call unrecognized. It was very, very unclear in the minds of state officials and in the minds of Bureau of Indian Affairs officials who had responsibilities. And there's historical reasons for that. In some ways, it's still not clear. But in the process of that, the Shinnecock Nation, for instance, had land transactions with the very first settlers that came to Long Island in 1640, the very first deed, December of 1640. Long-time colonial relations with the state of, rather Great Britain and the colony there, later the state of New York, and only recently, 2 years ago, did it become federally recognized and considered to have a federal tribal government-to-government relationship. But I began working for them long before that and assisted in their recognitions effort, including bringing lawsuit against the Interior Department in order to speed up the process of going through this federal recognition process that we now have, that I'm going to delve into and explain a little bit. So for the last 7 years, you can say I've been working with unrecognized tribes in several capacities, including getting one of them recognized. The Puspatuck Unkechaug are still not recognized, and I'll tell you a little bit about that. Now, recognition these days has a mystique to it. And if you go talk to a federal judge or a state judge, They think, ooh, it's something special. It's almost mystical. And the Interior Department has had a lot to do with that, and I'm going to explain that in a little bit. But let's back up for a minute and think of the word recognition just in its ordinary, what it means ordinarily. If I recognize you, it means primarily that I know who you are. You and I've met, I know your name, you and I've talked, I recognize you. Sometimes it means I recognize you to come up and speak in front of a group. So I was recognized to come up here and speak. These days, the federal government will tell you that recognition is a very, very special thing that means that they have recognized you the same way they recognize the government of Cuba or don't, the government of Iran or don't, what's going on in Syria. They will tell you it's the same thing. I will tell you that I think that is a bunch of baloney. It can't even legally be true. But that doesn't mean that you don't have lots of court decisions that are telling you that that's exactly what's going on. Recognition in the first instance means, and the way it was always used originally throughout history up until relatively recently, has had to what we now call a cognitive recognition, meaning what do I know? Do I know you? When the doctrine first began being discussed in the courts, that has led to the idea that there is such a thing as political recognition within the United States, it was in the context of the courts deferring to the executive and congressional branches in their relations with Indian tribes, either engaging in treaty negotiations or with any other kind of interaction that there might be that would have occurred. And the courts were saying that our job as courts is not to second guess what Congress and what the executive branch has determined when they're out in the field. And when they recognize that this is a tribe and this over here is a separate tribe, unless we have evidence that Congress or the executive is just completely out of bounds, we're going to acknowledge that. And we're not going to second guess it. We're not going to go behind it. And the first use of recognition in a case called the United States versus Holiday that gets cited a lot for this proposition, that's what they were talking about. Now, obviously, when you go back to the time when the United States government was entering into treaties with tribes, there was a certain aspect of recognition that was political. And that's because the executive, the president, was operating under the treaty power, not under the Indian commerce power. Now, under the treaty power, a president, whether it be with an Indian tribe or a nation anywhere around the world, is authorized under the Constitution to enter into treaties with the advice and consent of the Senate. And that is definitely a political function. Who the president decides to go out and enter into a treaty with around the world, and who the Senate decides to advise and consent, meaning approve the treaty, that is definitely a political function. But that function in Indian affairs ended in 1871. The United States Congress, in an Appropriations Act, insisted that they would never again recognize a treaty. Pretty much said, don't negotiate them because we're not going to ratify them. And we're not going to honor them. Since that time, the treaty power is irrelevant to this question of recognition. And you need to look at recognition as something that is not political, but rather has more to do with determining when there's federal legislation and the Interior Department needs to go out and implement that legislation. They have the very, very practical problem of determining who are we going to deal with. And therefore, they have to determine who's a tribe and who the leaders of the tribe are for the purposes of them doing their job under laws that Congress passes. So recognition changed in 1871, never to be political again, in my estimation. What we do have, however, is still the relationship between the judiciary, the courts, and the so-called political branches. And you still do have a deference, but you find that in many, many areas that has nothing to do with politics. It has to do with what the separate jobs are of Congress, the executive branch, and the judiciary. Now, beginning in 1891, Congress passed a thing called the Indian Depredation Act. It's a horrific thing, but the basis of it is the idea that sometimes Indian people, tribes, would engage in hostilities at that point. And Congress promised that under certain circumstances it would reimburse any of the non-Indian people that suffered a loss as a result of that. But in order to determine whether to reimburse it or not, one of the things that they had to do is determine whether the tribe was at peace with the United States or at war, and they had to determine for some purposes whether, for instance, Geronimo's band, was the Apache tribe acting in its official capacity, or was he a separate band and the Apache tribe was not responsible for what he and his band did? That gave rise to the need for the federal courts, which implemented, or rather, where lawsuits were brought under the Indian Depredation Act, to determine what was a tribe and what wasn't. And so a definition was born that we call the Montoya test, the common law test that applied and still applies in the federal courts to determine whether you are dealing with an Indian tribe for real and in law. Now, this Montoya test is very vague. It says basically an Indian tribe is a organized group under a particular leadership with a sometimes ill-defined territory, and that's about it. The purpose for it was to really distinguish between a tribe and a band is what they were getting at. But that definition maintains today. If you go to court, as I'll talk about in a little while, if you go to court as an unrecognized tribe that's not on the list of federally recognized Indian tribes, there may be purposes under which, for which you are going to need to prove whether you're a tribe. And if you are in court that long, for instance, if you are sued in your tribal capacity, you may want to say, I'm an Indian tribe, I have sovereign immunity from suit. And the court will say, how do I know you're an Indian tribe? One of the things you'll say is, I guess I'll have to prove it. Actually, it's the judge that's going to tell you you're going to have to prove it. And they're going to apply the Montoya test. And so you're going to have to go out and show that you've got a territory and a leadership and a defined membership, more or less. That's the way things were up until the Indian Reorganization Act was passed in 1934. And at that time, the idea of recognition is still pretty vague, and the Montoya test is all that there is. And a couple things happened in the 30s. One, the Indian Reorganization Act is passed, and Congress, you've heard a lot about this recently, I'm sure, in the context of the Carcieri or Carcieri litigation, where it's the question of whether the Indian Reorganization Act applies to a particular tribe and whether the secretary can take land into trust has to do with whether you're Indian, and whether you're Indian has to do with whether you are a member of a recognized Indian tribe now under federal jurisdiction. Now, I suggest to you, and what I'm going to tell you is what the Interior Department is also saying in litigation right now, that recognition, the term recognized in that sense did not mean political recognized. It meant more, like I was saying, cognitive recognition. And if you look into the legislative history, you can see how that must have been the case, because the bill as it was originally presented to Congress defined Indian as a member of any recognized Indian tribe. It didn't have the phrase now under federal jurisdiction in it. And there were long discussions with Commissioner of Indian Affairs John Collier about who would come under the act and who would not. There were a number of senators that were very concerned with who came under the act and whether they were going to take in Indians and take responsibility for them, federal responsibility, even though they weren't considered to be under federal responsibility at the time. And Collier said, yes, And an example was the Catawba tribe, which was in South Carolina, one of the original 13 states. The federal government didn't have any relationship with them. The BIA did not provide any services to the members of that tribe or to the tribe itself. But the Senate Indian Affairs Committee recently had held hearings in South Carolina and knew about that tribe. And so they kept asking about the Catawbas. And he said they would come in. Senator Wheeler, he had a problem with that. He only wanted, if you aren't already under supervision, he wanted it to be only if you were half-blood Indians. And he kept talking about California Indians, and he said terrible things about you. But the point is that Collier said, recognized tribe is too broad, apparently, for Senator Wheeler. If we add the phrase, now under federal jurisdiction, maybe that'll mean only the ones that are under federal jurisdiction will come under the IRA unless you're half-blood. Even if you're not under federal jurisdiction, if you're half-blood Indians, you're defined as Indians under the Indian Reorganization Act. Now this is important because it's not only the first time that Congress uses this word recognized, but also because these days that phrase is being litigated all over the country. It's important to every tribe, almost every tribe. There are a few tribes that no one claims they weren't recognized tribes under federal jurisdiction at the time, but you would be surprised, I am surprised, at how many tribes that everybody knows and have always known about and have had treaty relations with the United States for years. The unbroken relationship with the United States are considered where there are challenges to whether they were in fact under federal jurisdiction in 1934. Naturally, a lot of them are in California, but it includes also, believe it or not, the Oneida Nation in New York. Now, after the Indian reorganization, let me back up just a second. For purposes of the IRA, the Interior Department had to determine who to hold elections for. If you recall, within a year, and then it was 2 years, everyone was supposed to, the Interior Department was supposed to hold an election on every reservation in the country to determine whether the tribes would allow the Indian Reorganization Act to apply to their reservation or not. And in the process of doing that, the Interior Department had to figure certain things out, and they came up with what are called the Cohen criteria. And if I can find those very, very briefly. Felix S. Cohen wrote, while he was in the solicitor's office, and published in 1941 the first handbook of federal Indian law. And in it, he explained what the Interior Department had been doing for 7 years in determining who to deal with in terms of allowing to organize under Section 16 of the IRA, to adopt constitutions, and also where to hold elections. And those criteria were very vague, and you can find them in the chapter where he deals with recognition. And although I've got them in front of me, here we are. He said that the considerations which they considered, whether singly or jointly, were whether the group has had treaty relations with the United States, whether the group has been denominated a tribe by an act of Congress or an executive order, whether the group has been treated as having collective rights in tribal lands or funds, even if not expressly designated a tribe, but just collectively have rights in land and funds. Whether the group has been treated as a tribe or banned by other Indian tribes. How rational. And finally, if it has exercised political authority over its members through a tribal council or other governmental forms. And then it says, other factors considered, though not conclusive, or existence of special appropriation items for the group and the social solidarity of the group. That's what Cohen had to say. That was his explanation of what the Interior Department was doing in implementing the IRA. Now, following the IRA, there was a backlash, what we call the termination era. And even before Congress told them to, the Interior Department began trying to absolve itself of responsibility for tribes. Fewer offices, fewer services, less responsibility for fewer tribes. And the Indian Affairs Commissioner, every year when he reported to Congress, almost gleefully would explain how much less responsibility the Indian Affairs Division was taking that year than it had in previous years. Says, we know what you want, Congress, we are winding down. Now this is important because this is when the recognized, unrecognized distinction is created by the Bureau of Indian Affairs. They began to look at themselves as only dealing with recognized tribes and not having any responsibility for unrecognized tribes. Sometimes they looked at it as landless tribes were not tribes that they had responsibility for. Also, tribes that they'd once dealt with that they'd forgotten about. Unrecognized categories where they ended up. Tribes that they knew about but had never provided services to. A lot of the tribes in the East fall into that. End up being considered unrecognized. Now this didn't happen overnight. It happened over a period of time, and it came to a head in the 1970s. And two sets of things happened that brought it to a head. The first was a couple of lawsuits. One involving one of the very first Eastern Indian land claims under the Non-Intercourse Act brought by the Passamaquoddy Indian tribe, and also the Penobscots as well in Maine. And in litigation that was reported in 1975 in the District Court of Maine and the First Circuit Court of Appeals, the federal courts, the Passamaquoddy tribe sued the United States and said, you have a responsibility to represent us in helping get our land back because you know it was taken in violation of that Non-Intercourse Act. And the federal government said, we have no responsibility for you because you are not a recognized tribe. The court said, the Non-Intercourse Act says any tribe. It doesn't say any recognized tribe. And the Passamaquoddy is a tribe. You, federal government, in this litigation even admit they're a tribe. You're simply saying they're not a recognized tribe. It doesn't matter. You owe them a responsibility, whether they're recognized or not. 1975, First Circuit Court of Appeals, you still see that case cited all over. Another one, less well known, involved the Stillaguamish Indian tribe up in Washington State. And that was one of the tribes that had been involved in the Washington fishing rights litigation that resulted in 1974 in what we call the Bolt decision, United States versus Washington. And it had been allowed to intervene in that litigation over the objection of the United States, which objected that it shouldn't be allowed to intervene and participate in the litigation because it wasn't a recognized Indian tribe. The court said, I don't care, let them in. Entered judgment in favor of the Stillaguamish tribe, along with other tribes. When it came time to implement the rights under that decree for the tribes up there, the federal government provided services to everybody, all the tribes up there that were beneficiaries of the decree, except for the Stillaguamish. So the Stillaguamish sued the United States and said, you owe us the same services. The federal government says, no, I don't. You're not recognized. We have no responsibility for you. Not surprisingly, the district court again said, doesn't matter. Doesn't matter. They've got rights under the treaty. As near as we can tell, these are the same people that you entered into a treaty with 100 and something years ago. They've got rights under the decision. You owe them a responsibility. That was in 1976. And then the clincher was the American Indian Policy Review Commission. Congress had created in the 70s a policy review commission. It had all of the best, most knowledgeable people in this area, including in law, at the time. And there was an entire task force dedicated to recognized, unrecognized tribes, rather, Task Force 10. It wrote a huge report. These days, I've only got a photocopy of it. It's this thick. This is a copy of the final report issued a year later, May 17, 1977. It has Chapter 11, called Non-Recognized Tribes. And what it has to say about the federal government: inconsistencies and oversights in the Indian policy of the United States are exposed by one stark statistic. There are more than 400 tribes within the nation's boundaries, and the Bureau of Indian Affairs services only 289. And it says in here that there is simply no excuse for the BIA to fail to provide services for what it identified as another 111 tribes that they knew about, that the federal government, the Bureau of Indian Affairs, refused to deal with and provide services to. And they called for the creation of a recognition process, quite a bit different than what we ended up with, as you might imagine. They said, we think the Bureau of Indian Affairs should have to prove if you're not a tribe. Otherwise, you should be recognized as a tribe. Within 1 month, the following month, June 1977, the Interior Department published proposed regulations creating an acknowledgement process and asked for comments. Those regulations weren't half bad, in my estimation. They were, in large measure, similar to the Cohen criteria. They actually contained criteria such as whether a tribe was recognized as a tribe, an Indian tribe, by other Indian tribes. That was important. It put the burden, however, on the tribe to demonstrate to the Bureau that it was in fact a tribe, but it wasn't going to be nearly as difficult to do as eventually it became. Those regulations were scrapped a year later. In 1978, the Interior Department proposed different regulations, very, very similar to what was eventually adopted at the end of the year in 1978, that became and created what we call the Federal Acknowledgement Process, Administrative Acknowledgement Process. Those regulations were adopted in 1978. The regulations were changed in some cases substantially in 1994. They are found in Part 83 of Title 25 of the Code of Federal Regulations. That's what you get to deal with these days if you are an unrecognized tribe that wants to become a federally recognized Indian tribe. Very, very briefly, there are 7 mandatory criteria. The process is, these days, that you file a letter of intent. I'm not going to go through all of these. I think that there are people following me that will perhaps address that more. I just want to talk about a couple of the mandatory criteria and the changes that have ensued since 1978 in becoming recognized. The most important of these criteria are the first, that you be historically identified as an Indian tribe. Now, documentation is what they're talking about. You want to find news articles, Interior Department, Bureau of Indian Affairs reports talking about you as a tribe. It's important from the Bureau's point of view that they talk about you as a collective entity and not as a bunch of Indians, because if they say, oh, there's some Indians over here and we think they're this, they'll say, that doesn't identify you as a tribe. That doesn't identify you as a group. They're looking for identification as a group. They're going to want it every 10 years. They're going to want it since the creation of the United States government. The rule is, since first sustained white contact. But for a lot of the tribes, that's a long, long time, long before the creation of the United States. In the Shinnecock case, it's 1640. So a number of years ago, they, through a guidance, said, we're going to interpret that as meaning 1789, the creation of the United States, because it's federal recognition after all, it's a government-to-government relationship. Why should you have to prove anything before we even existed? And in some cases, it may be later than that. So it's first sustained contact or 1789, whichever is later. Every 10 years, you're going to have to show certain things. You're going to have to show that you are descendants from an historic tribe. That turns out to be, I found, one of the harder things to do because, again, determining who the historic tribe is, when they say they want to prove that you're descendants, they're going to want to show direct genealogical descent for as long as you can come up with it. And that means you got to hire a genealogist, and you've got to have everybody in the tribe come out, and you've got to dig up birth certificates, death records, family Bibles, whatever, and go through this whole family tree of everybody in the tribe. And it's incredible what the Bureau of Indian Affairs is going to do. In some ways, it's very impressive what it is that they do. They start churning all this data, and they figure these things out. I mean, they look at, one of the things they're going to want to do for a different requirement is find out, you know, who everybody's been married to, whose kids did you marry inside the tribe? If not, did you marry other Indians? If not, and they do percentages, and they do them every 10 years. And it matters for purposes of the second criteria, which is really, really important. That's community. You got to prove that you're a community. One of the ways you got to do it is proving that you got a certain amount of intermarriage as opposed to always marrying out. You got to be, it's very good if you all live together. If you've got a land base, it's really, really helpful. If everybody lives on the land base, extremely helpful. The Shinnecock Indian Nation, very, very lucky. They ended up with 812 acres in Southampton. Southampton is their traditional territory on Long Island. Very, very rich place, but they ended up with still an 812-acre tract down on the water that where they've been since long before the colonists, but during that entire time. Also very lucky. 1792, the New York State said, in order to deal with the Shinnecocks, we're going to require them to have 3 trustees. They created a government for them and said, you're in charge of all the land, and you're going to be elected every year by the males of the tribe, and the town of Southampton town clerk is going to keep track of that every year. Now, these days, when it came to getting recognized, my God, that was decisive, because that tribe had records going clear back to 1792 of every election almost. Some of the records were lost, showing political authority, community, living on reservation and whatnot, voting for leaders. Very, 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 very helpful. The third criteria, extremely important as well, called political authority. And there's a crossover. The better you show community, the less need there is to show political authority, and vice versa. In the Shinnecock case, they showed political authority through that system that I just told you, and didn't have to show anything else about community. You're also going to have to show that you've never been terminated. In other words, Congress hasn't passed legislation saying we refuse to deal with you. That's the problem with Lumbee, for instance. Everybody knows Lumbee's a tribe. Congress even recognized them in a statute, and in the same statute said, but we don't want to deal with you. And so they are prohibited from going through the administrative acknowledgement process, which means unless Congress does something, they're prohibited from being federally recognized at all. You've got to have a governing document, and as I said, you've got to show a list of your members. Now, part of the tragedy in all this is that the Bureau of Indian Affairs won't admit this, but everyone that deals with the system knows it's true. When this system began, it took maybe this much paper to get through and get recognized. The first tribes that became recognized did not require very much documentation, did not require very much time. Over the years, I don't know how many, it's tens of thousands of pages of documentation that the Shinnecock had to put forth. The most recent tribe. The tribe before that, Mashpee Wampanoag, same. Tens of thousands of pages of documentation. Millions and millions of dollars spent on attorneys, in both cases, suing the federal government in order to get them to do their job in some reasonable period of time. Shinnecock, by way of example, are considered to have been number 4 of number petitioners. They had a petition what was considered to be a petition on record before the acknowledgement regulations were even adopted. There were 40 tribes, or 40 petitioners that were. 30 years later, we went into court and said, we think that's too long. And under a thing called the Administrative Procedure Act, you can get a court to tell an administrative agency to hurry up. You can't tell them generally what decision to make, but you can tell them do it soon. And that's what we did. And that took years. Historians, ethno-historians, and genealogists, millions of dollars spent by these two tribes each in order to get this through. And with every recognition, they said this after Mashpee Wampanoag, the same people they're saying it after Shinnecock. The bar is going higher. You can just feel it. The bar is higher. The next tribe to get recognized, it's going to be even harder. And I'm sorry to say that, but that's the reality. And then I'll give you a little bit of a litigation perspective. I don't know any way around it at this point. If you want to become federally recognized, other than going to Congress. And I tried. I've spent several years of my life not only getting them to hurry up, that wasn't the only thing that was part of our lawsuit, to get the Interior Department to hurry up. I also brought, I understand that there are some Muwekma people here. We followed what they did. They had proven that they had been previously federally recognized, and that they brought a lawsuit in part claiming that their rights to equal protection were being denied. We claimed the same thing. We got shut down on everything except for the unreasonable delay claim. The judge said on all of these, I can't make a decision. It's not my job. It's the Interior Department's job to make the decision. When they make the decision, then you come back to me if you don't like the decision that they make. But before that, I'm not going to make a decision. And in the end, it comes down to a doctrine called primary jurisdiction. Even though the courts in the past have determined whether a tribe's a tribe for virtually all federal purposes, and even though the very first list of federally recognized Indian tribes included the Passamaquoddy and the Penobscot, not because the Interior Department had done anything, but because the judge had told Interior that they had to file a lawsuit on behalf of that tribe. The Government Accounting Office says that the date of recognition reported by the Interior Department turns out to be the date that they filed the lawsuit under court order that they didn't want to file. That constituted recognition. They were on the first list. So what a court says has always made a difference. But with this new program, what the courts are saying is that under this thing called the doctrine of primary jurisdiction, it's true that I, the court, have jurisdiction to do this. It's also true that there is an agency that has primary authority to deal with the subject matter. Under those circumstances, you can come to me if they're taking too long, but you go to them and deal with them. If you need relief over their process or whatever under the Administrative Procedure Act, I will grant you relief. I'll even, ride herd on them, which is what we did, and the Mashpee Wampanoags have done, and the Muwekma Ohlone did. But I'm not going to make their decision for them. You're going to have to let them make it, and then come to us. And unless Congress changes it, I don't know how to change it. Other than, the Interior Department itself could change its regulations. But it seems to be entrenched. Now, there is a task force. There are people that are working, trying to come up with a change, a fix, if you will, to the recognition process. Congress holds hearings about it. I think it was the Interior Department. I don't think that Kevin Washburn, who's the new Assistant Secretary, has said this. I'm not sure. I know that when George Skabeen was acting, that he testified to Congress that he's looking at, Interior is looking at fixing the process. And there are definitely people out there that have been dealing with this over the years that are working on it. And a way to find those people would be, last week the National Congress of American Indians was in Sacramento. And one of the things they did on Tuesday, I think, was to have a meeting of the task force. Actually, it was Sunday afternoon, now that I think about it. They had a meeting of the task force just to discuss where things are at. and there's a couple well-known people, including, look up Arlinda Locklear, Lumbee, longtime attorney, argued in front of the U.S. Supreme Court in one of the Oneida cases on the Eastern land claims, but also very, very interested in this question of recognition, in part because I'm sure that she is Lumbee, and I've told you about them. So you can always go to Congress, and there are some tribes that are doing that. For instance, the tribes in Virginia. There are in recent Congresses, as there is in this Congress, I think, and I don't think it's been passed and signed yet, the Virginia Indian Tribes Recognition Bill. They've got an interesting story because, you know, the tribes that greeted the first settlers, English settlers, are still there, and they're considered to be non-recognized. The very, very first tribes that white people dealt with when they got here are considered to be unrecognized. The British know that they're there. Dianne Feinstein is not looking, she's not a proponent of Indian gaming. She is one of the people that is holding up a fix to the so-called carcieri fix legislation that has been put forth ever since the decision. And her concern, everyone knows about, is gaming, and particularly off-reservation gaming, but also gaming in urban areas. And the last thing she wants, I mean, frankly, one of the reasons that Malek-Maloney is having the problem that it has is because of its location. If you're smack dab in the middle of a metropolitan area, they're looking at it going, oh my God, what's going to happen if they become federally recognized? So you can go to Congress, you can go to Interior and participate in trying to get this thing fixed. And then I have a couple other suggestions. I've already told you about some of the legal complications of not being recognized. For instance, sovereign immunity. You still can prove your federal status in court if your federal status is raised in a way that doesn't implicate this primary jurisdiction of the Interior Department. And so the Puspatuck tribe that I represented on Long Island, for instance, they're one of the tribes engaged in the smoke shops. And they were sued by a large grocery store chain, Gracie's Foods, trying to shut down all of their smoke shops. That's basically their economy. They've got a very, 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 very small tract of land, but they're in Long Island, and they sell cigarettes. And as we were representing them, we claimed sovereign immunity. That tribe had to go through and demonstrate, not nearly as much difficulty as going through the recognition process, but nonetheless on a motion for summary judgment, showing documentary evidence where the judge says, I think more likely than not, you meet the Montoya criteria, you're a tribe, and you have sovereign immunity. Now the danger there is every time you win, you don't get to use that the next time around against a different litigant. The way the legal rules work, the way I figure it, under this doctrine called collateral estoppel, anybody that beats you and proves you're not a tribe, everyone else is going to be able to take advantage of that because you're the same party to the litigation. Anything you lose, you lose. But the problem is that every time you win, it's probably going to be a different plaintiff suing you, and they're not bound by what the other plaintiff lost. So it's continuing to prove that you're a tribe in litigation, very dangerous, I think. And the other, I don't think necessarily has application out here, but it's in land claims. There are certain statutes, such as the Non-Intercourse Act, where you still can go into court without having to go through the recognition process, without going to the Interior Department, and prove under the Montoya standard that you're an Indian tribe. But beware, if you go through the federal recognition process and get declined, they determine they're not going to recognize you, you will never be able to prove again that you are a tribe under Montoya. The Golden Hill Pegussets did that. They lost. Most recently, the Scatticokes had their land claim dismissed on the grounds that there is this, again, collateral estoppel, issue preclusion. They lost certain issues in front of Interior Department. They can never, ever go to court again in order to prove that Interior got it wrong, other than a direct challenge, and that they really are a tribe. So very, 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 very dangerous process. I know that you're going to have a summit and that you're looking for topics, and I thought a little bit about that. Other than going through the federal recognition process, trying to find the money, all the documentation, the experts to assist you, you can try to participate in and hope that the recognition process gets fixed. I don't hold out a whole lot of hope that it's going to get fixed sufficiently so that it still isn't extremely expensive and extremely difficult and extremely time-consuming to go through. However, if you do get in that situation, you do have 3 tribes now that have gone through that have, I think, laid out at least a litigation path for how you can get the Interior Department to at least move reasonably quickly, not real quick. Can you imagine taking 20 years or even 10 years to a lot of the things that a federal agency would do? You know, you need approval for, well, I won't even go into it, but I don't think there's any place else in the federal government where anyone thinks it's reasonable to take 10 years in order to make a decision on something. That's one of the nice things about courts. You go give them all the stuff, they look at it, say, I got to make a decision, I'm going to make a decision. A year later, a year and a half later, you're done. Interior Department, my God, it takes years for, they're doing about 2 petitions a year. Okay, so recommendations, other than ones I've already given you. I would seriously consider trying to, in California, see if you can get the state government to engage in a state recognition process. And I say this because it doesn't get you everything, but it gets you some things. There are some federal statutes that actually define Indian tribe to include state-recognized tribes. The Indian Arts and Crafts Act is an example. The Indian Education Act, there's some benefits for state-recognized tribes. There's a couple others. So, and there are places where there are state-recognized tribes, and there have been for a long, long time. New York had the 2, and still has 1. And there are other tribes in the East, states in the East where they do this. And it's clear that Congress thinks it's okay. Otherwise, they wouldn't define tribe to include state-recognized tribes. And they define that in this legislation as saying any tribe that's recognized under the state's, whoever the state says can do it, and whoever they recognize, that's a state-recognized Indian tribe. I would suggest that, considering what I understand to be the logistical problems, the practical problems of tribes in California, that getting some legal recognition of your status would be wise, and that you might be able to do it with the assistance of the state. I don't know how to go about doing that, although I do know a couple people, including one yesterday who's a lobbyist in Sacramento. I asked her if she'd be willing to help, and she said, yeah, let's talk next week. I think she would. She's interested in many of these things. And I would suggest that if they do it, that they don't ape the Interior Department process. Go back to the Cohen criteria. Go back to make it so that if my neighbor says I'm an Indian tribe and you know they're an Indian tribe, well, take their word for it because they know better than anybody. Something that people can actually qualify for, that doesn't take an arm and a leg and a couple $1 million and years to do, would be my suggestion. Go back to the Cohen criteria. Go back to what the American Indian Policy Review Commission suggested. And then on the federal level, that might, for instance, help you at the state level with including some things, for instance, cultural resources issues that you may have. But coupled with something else that may be easier on a federal level, it may actually assist you on the federal level. Congress already does have some legislation that provides some benefits, very few, but some, in standing for state-recognized tribes. If you could come up with a state recognition process, you might also be able to keep trying to get Congress every time that it makes sense from Congress's point of view, and there's not too much political opposition, to get them to include the definition of Indian tribes to include state-recognized Indian tribes. And little by little, it may not be this full federal government-to-government relationship that that has, come into existence. but at least it's legally acknowledged existence and legally defined rights, and who knows where you could go from there. Those are my only suggestions. And I think I started a little late, so I think maybe we still have time for questions? Good, wonderful. Thank you. Yes?
Pawcatuck, Pequot, and Eastern Pequot, what's their, they were able to get through the Part 83 process, and then under the Bush administration, they yanked the rug out from underneath them. Same thing with the Wabash.
Yes.
And so do they fall under the same, they don't have the same issue as Scaticoke or Bowling Hill, do they? As far as you know.
No. There are a few things, of course, that I didn't mention, one of which is that there are tribes that have gotten around this whole process, including a couple in California. Lower Lake Rancheria is one of them. In the end of 2000, Kevin Gover, there were 4 tribes that he said, oh, we made a mistake. They should have always been on the list, and just declared them to be added. And he did that early enough at the end of that administration that it went through, and there has been a concerted effort by certain people within the Interior Department to undo that, but they have not been successful. The Ione ban was another. The last administration, the Bush administration, they pulled an opinion. It's been reinstated, having to do with other aspects of their legal status and whatnot. And that includes these couple other tribes. There were some that weren't early enough late in the administration to survive, and when the Bush administration came in, they kept them from getting published in the Federal Register. It takes about 30 days to get to the Federal Register. So if you're the end of an administration and think you might have a little bit of pull, that's the time when a lot of these things get done. That's when pardons get handed out by presidents, and so where a lot of things that people that have the power to do things that think that they're willing to do one last thing that they've got power to do that politically they wouldn't be able to get away with if they did it anywhere other than at the end. And I think they've learned, do it early enough so it gets published in the Federal Register so it's hard to undo, and don't do like what happened with a couple of these others, which is they get reversed by the new administration before they actually end up becoming legally effective. Yes? Sure.
Perhaps you can clarify something. It was my understanding that some of the proposals for individual tribes that in legislation for recognition, some of the opposition was catered to by including a non-gaming clause, and that the Interior Department actually prevented it from happening because they didn't want that to be set as a precedent. Is that true to your knowledge?
I don't know. I wish I knew, but I don't. So I'm sorry, I can't say. I will look it up. I will give you my card, and I will go back and look that up, and you can call me, and I'll find out the answer for you. Okay? I know there were a couple others, yes?
I was wondering what you thought about if the California Indians would have a separate and unique history from other states, and the fact that we've already been recognized by the Bureau of Indian Affairs by issuing CIA roll numbers that have been certified that we were here before 1850, before California became a state. What if the unrecognized tribes of California banded together and said, you know what, we reject the recognition process because we are already recognized, and that we believe that the state of California should revert back to what it was before, and all of the Indians who have roll numbers and their descendants are eligible for services, and the state of California is to be treated as or on a reservation.
Oh. It works for me.
Me too.
Yeah. I don't think the Interior Department or a federal court ordering the Interior Department, that there's a great likelihood of them going along quite with that. There's one thing that I didn't talk about that what you're saying is raised, and that's this question of previous unambiguous federal acknowledgement. I didn't tell you that in the regulations, there's some things, if you were previously recognized as an Indian tribe, there's some things that you only have to prove, not back to first sustained white contact or to 1789, but only to the time you were previously unambiguously federally recognized. The issue more recently has become, and what on earth is that? And one of the bars that has been raised by Interior is over this question of what constitutes unambiguous federal acknowledgement, previous federal acknowledgement. And it turns out that if what you are is the superintendent knew about you and reported you to the Commissioner of Indian Affairs, and he reported you to Congress every year as he and they were required to do for years and years, that won't be considered to be unambiguous federal acknowledgement. I found this out in Shinnecock. We went in and said, my God, you had the Commissioner of Indian Affairs reporting to Congress every year from 1915 to 1924 that this was a tribe under their supervision. Why isn't that unambiguous previous federal acknowledgement? And they said, because it takes more than that. That just proves that we knew you were there. It doesn't prove that we had a relationship with you. You go, you're supervising us and that's not a relationship. No, not if we didn't actually do something. So,
although in the Hillary Tompkins writing regarding cowlets,
thank you.
it's any federal action.
Well, this is where everything kind of comes full circle in a way, is that I don't think that they're going to change their mind about what's unambiguous previous federal acknowledgement for recognition, but what they have done is taken all that information and all that argument that was presented to them and say it's relevant for whether you're, quote, under federal jurisdiction in 1934 for purposes of whether you're an Indian under the IRA. And Cowlitz is the case where Interior chose to make, that's where it's being litigated right now, where it's probably going to get decided. It's being litigated in some other cases. And what they came out with is kind of a hybrid of what all the things were that we sent into Interior after Carcieri, saying, do this, look at this, adopt this approach. And they've adopted kind of this hybrid approach that includes whether you are under the administrative jurisdiction, the supervision of the Interior Department, meaning that they reported that they knew about you. And Interior is saying, if we put you on one of those population schedules and told Congress about you, you were under federal jurisdiction. And you're Indian. And that's extremely helpful because almost all tribes, at least all federally recognized tribes come under that. But I haven't answered your question. Go ahead.
The services for California Indians and the roll numbers that were generated is from a lawsuit. We're the beneficiaries of winning a lawsuit. And how does the BIA justify discontinuing those benefits that were won by in the court of law over 50 years, and the fact that all California Indians with a roll number paid for all of the rancherias that are now recognized? We're interest holders.
Okay. Now remember that I don't work for the Interior Department, and so you're asking me how they justify it.
How do they
And
get
all
away
I can do is tell you, the best of my understanding, how they look at it. The lawsuit you're talking about, I think, was before the Indian Claims Commission?
Yeah.
You're talking about the judgments.
California judgment.
And if you recall, in most cases, those lawsuits were not brought by tribes, but by, quote, Indians of California, represented.
Right, but they were tribes.
I know that, and you
they
know
had to
that.
get the vote of the tribes.
I absolutely agree with you. If what you're trying to do is ask me, do I agree with you? I think you're right. I do. I think all of this, I don't know if this came through. This is a bunch of baloney, this whole thing. And that's why I went back to the past to tell you where it came from. It came about as a way for the Interior Department to defend themselves from this criticism where the courts were saying, we don't care, you got to do it. The Policy Review Commission was saying there's no excuse for what you're doing, you got to fix it. There is no legal justification in my mind for what they did or what they're doing. Don't
Only that
mistake
nobody's
that.
brought a suit
Don't,
against
don't
them for
mistake that. And I've,
Yeah. What we need is another California Indian claims case on recognition.
I think that's what your summit's for, brainstorm.
Yeah.
I don't know how to solve the problems. I wish I could come here and say I had a roadmap laid out. I don't know. I'm thinking about it. I think about it a lot. And I've given you the best I can come up with thus far. But I think you're right.
Yeah, Kane, I'll try to talk to some of that when I do my presentation.
Yes, sir.
Oh, real quick question. You had talked about the Shinnecox and that they had this rich documentation set.
Yes.
That sounds like it would have been a slam dunk, but I get the impression it still wasn't. Does that speak to just how?
We will, it does. We will never know how, we will never know exactly what went on inside of Interior. We didn't know by bringing a lawsuit whether it may, we knew we were pissing certain people off for sure.
Yeah.
We didn't know if that meant, geez, they're going to get us if they can. I mean, we were figuring out what are the ways they could get us and what can we do about it. In the end, just as with Mashpee, we beat them in court. They still turned out to recognize the tribe. And yet, part of this bar that keeps getting raised, the difficulty, is when you get in this process, they go through what's called technical assistance. And technical assistance is when they say, okay, we've read what you've said and you've provided. Now we've got this list of questions and we want you to answer those and provide documentation. You say, okay, I'll spend another year and a half. I'm going to look up all these documents, write another report, spend another $1 million. And then they say, okay, now we've got this one. And so they put you through the process. You can declare yourself ready anytime you want.
Right.
And then they'll go through and say, well, you don't meet this one, and that's it. So if you're going to go in the process, it's good to go through and take seriously what it is they're trying to tell you. There are actually people in the department that are rooting for you. And of course, there are people that aren't. And one of the...
It's like asking the burglar to, how to secure your own house.
Yeah, they know best. Sure.
When do you think the department and the BIA feels like it's reasonable that this process should be just chucked out and done away with? And the California Indians, when are they going to get tired of applying? When are we going to get there? 30 years?
I don't
It's too
know.
long.
One good thing I can tell you, all or many of you or some may have heard of an individual by the name of Scott Keep.
Yay, Scott Keith.
Scott Keep was the head of the branch for Alaska and Governmental Services, or whatever it was called. And one of the great things about this administration and Hillary Tompkins and whoever supported her, I mean, I think probably Secretary Salazar and certainly others, they sidelined Scott Keep. He's not in charge of anything anymore. He has not, his division has been abolished. He is now under the associate solicitor. He does only what the associate solicitor gives him and nothing more. And he has been one of the people who have been the most adamant. Everybody knows this. He doesn't believe there's tribes in California.
Right.
And he's been sidelined, and one of these days he's just going to be gone. And that's been, we've already seen in a lot of the dealings with Interior and a lot of, like Cowlitz, for instance, he has to have been one of the people that was 100% absolutely against what the Interior Department came up with following Carcieri. From his point of view, no tribe under Part 83 qualified as an Indian tribe under federal jurisdiction in 1934. Narragansett was a Part 83 recognized tribe. They lost, everybody else loses. That's where we think he was coming from, and a whole lot of worse things. But he obviously lost and he got sidelined, and that's really good news. So that's the best I can offer.
Yeah. He also believes that he is there to protect the United States of America from American Indians.
I think that's true.
There might be some.
Sure.
I had another question on the UN DRIP
Sure.
and the rights of indigenous peoples. is there a way, you know, I know it's new and I know that the federal government's still saying it's a nice little aspirational speech that was talked about. But at the UN, they're saying that it is real, that the government has the responsibility to implement the powers of the DRIP, and that if the California Indians wanted to pursue something under human rights and the mistreatment of denial of services equals cultural genocide or genocide by withholding services, education, there's no mechanisms in place that count suicide rates, teen pregnancies, health conditions of unrecognized people. That's a discriminatory act against a race of people.
Okay, the United Nations Declaration on the Rights of Indian Peoples, UNDRIP, is a terrific, terrific document. I think that we are only at the threshold, at the beginning of seeing what we might be able to do with it. I myself can't, particularly since I'm being recorded, cannot talk in a too detailed a way, but I do think that it can be used in litigation. It's a declaration, it's not a convention, it's not a treaty, and so you can't go into federal court saying, here there's a violation of this, do something about it. In addition, under the international system, the United States has done a very, very good job of making sure that it is extremely difficult to bring the United States to task in international forums for anything that it may have done. Under the human rights conventions, for instance, it's declared that they are not self-executing. Only if Congress passes legislation implementing them will you be able to go into a federal court in order to challenge violations of rights under the human rights covenants or conventions. Under, if you want to then bring suit in the International Court of Justice, you're going to have another country bring suit on your behalf. At which point they do have standing to raise an issue in the International Court of Justice. I think that the best, if we're looking at, there is of course the permanent forum, there is the Human Rights Commission that you can go before. They don't really have authority to do anything other than require the United States government to answer for what is going on, which itself is a powerful thing. Having those countries and commissions and whatnot, and forum tell the United States, we've heard about this, we want you to explain it, require the State Department to write official reports. That actually can be very, very helpful. And then finally, because I am going to answer your question this way, is that I think we are heading toward, if we aren't there already, where the declaration is becoming what's called customary international law. Whether we're there yet or not, I'm not certain. It requires, in addition to there being this broad consensus internationally as to what the rules are, and we have that, it also requires countries to conform their conduct out of a sense of legal obligation. When that happens, that's customary international law. When that happens, that's part of federal common law. And that you can do something about in the federal courts. And I think that that's where we're headed. Sure. I'm up here as long as they say it's okay.
As far as organizing the summit for California Unrecognized, and the UN is evaluating, or the United States is submitting their ICERD this coming year. And if the California Indian people could band together and write a shadow report somehow highlighting what's happening here in California and the history that we've had, and how unjust it is to ask us to now prove that we're the very people that they exterminated.
Absolutely.
Their attempts to annihilate every tribe in California.
Yeah, that got up there too. That's the International Covenant on the Elimination of Racial Discrimination. And absolutely agree. Very, very good idea. Tell the United Nations about things, submit a shadow report, require them to then ask the United States, what's the problem here? What's the problem there? And get federal attention. I can't tell you that any specific good result's going to come from that, but the instinct of everybody that's been working on this stuff for 30 years has been that good things are going to come out of this, and I think we're already seeing some good things. And
And that is a convention that
hope-
the United States signed on.
and it is. And I'm confident that, well, anyway, so if we're,
So, thank you, thank you.
thank you. It's been a great honor.